every Tuesday at 5 p.m. Central Time. For 1 hour, we take live question and answers and give you the immigration updates. Emily, what do we have today to discuss?
Today, we want to talk about what employees can do to protect themselves from the negative impacts of these multiple H-1B filings. So we've been talking about for the last couple of weeks since USCIS came out saying hundreds of thousands of the registrations that were submitted for this year's H-1B lottery were duplicates. We're contacted every day by people who had multiple registrations submitted and are worried about what's going to happen. And so we'll talk about what you can do now to try to protect yourself in the future so you don't face problems going forward. And we'll also talk about strategies for staying in the United States and continuing your job search during the H-1B grace period and also beyond the H-1B grace period. If you run out of time, what are your options available there? A common question we get is, how do I know if my I-140 approval has been withdrawn? And this is important to know if the withdrawal happened within 180 days after approval if you've left the company, because that determines whether you can keep using that I-140 approval to get H-1B extensions beyond the 6-year limit, whether your spouse can continue to extend the H-4 EAD. But sometimes it's a little tricky to find out what the status of your I-140 is. If you go back and ask your company, hey, did you withdraw my I-140? They might go ahead and withdraw it. So you don't want to trigger that. So we'll talk about how you can figure that out to ensure that you can keep getting those H-1 extensions. And then these days we're back to the same old delays in I-485 case processing. What is taking so long? What steps can you take to try to speed up the process? Can you contact USCIS? Are there other options available?
Emily, let's discuss on this hot topic as we see that day in and day out, people getting lifetime ban for entering into the multiple H-1B filings. We've seen people getting deported. We have seen people getting intent to revoke. We have seen people getting intent to deny the H-1Bs. We have seen all kinds of things at this point of time, mostly because what the USCIS is alleging that the employees colluded with the employers. They conspired with the employers to defraud the immigration for getting the immigration benefits, though. There seems to be good truth about good number of cases, though, but at the same time, there seems to be some misguided information given by many different lawyers, and they relied on those things. And there is also some people who are completely innocent. They are not aware of. Of course, everybody knows the law. If not, I will remind them that not knowing a law is not an excuse in the law. That I don't know that this is illegal is not an excuse. Now, of course, we have seen, Emily, that you're telling that from past 3 weeks, you're having this discussion. But if I go back to February of 2022, you on the YouTube, and particularly it's been watched by approximately around 14,000 people at that time, 1 year ago, February of 2022, I asked you the question, can a person apply H-1B lottery with 10 different employers? And you clearly said no. And I asked you the question, well, what if I have multiple job offers? And you still said no. At that point of time, can you explain why you said at that time? While there are other lawyers that I don't want to name them, but they clearly said you can file it as long as you have the job offer.
Yeah, so I mean, it all comes down to an interpretation of what the statute says. And the statute does make it very clear that one person can have multiple H-1B approvals. There's no restriction on that. And if you've got multiple H-1B approvals, you only have to be counted in the cap once. That does not mean that one person can file multiple petitions in the lottery or multiple registrations with companies that do not have legitimate job offers. And so this issue actually has been around for years during this lottery season, even before the electronic registration system came in. Back when we were filing actual petitions, employees would go to multiple employers and say, hey, can you file a petition for me in the lottery? 2 companies would file or 3 companies would file. And back then they would get selected and then the companies would file and you get the approval. And then even back then, I mean, even going back to 2018, those petitions were later being revoked because it came to light that there were so many similarities between the filings of the 2 petitions. Sometimes they used the same attorney. They used, their letterheads looked very similar. They were sharing office space or they were very close to each other. They used the same FedEx account. They had the same signing person, or they had people that were running the 2 companies that were related to each other in some way. I mean, there are so many overlaps between these multiple companies that USCIS came out and said, it's clear you've colluded, and they've actually published this as a precedent decision, matter of S. So this is not a new concept. So we've been saying all along, that is not what they mean by allowing multiple petitions. You've got to have legitimate job offers. And so we were trying to warn people that these things were going to be happening, and notice of intent to revoke, notice of intent to deny, fraud findings were going to be happening if you continue to do this. The electronic system just made the whole thing worse because it's so much easier and cheaper to submit a registration compared to filing a whole petition like we were doing prior to 2020.
So Emily, one thought of the process is, how do we protect these people right now? I made some of the notes that if you have not filed the H-1B, you have filed multiple applications though, do not file the H-1B. Tell the employer not to file. If the employer has already filed the H-1B, they can withdraw the H-1B application right now. Even if the H-1B is approved right now, they can still withdraw the H-1B because technically it's not counted toward the H-1B if it is not crossed until October 1st. Also, if there is any information that you have that it is the employer that did these multiple filings, so he is the one, hey, it's better if I do this one for you instead of you encouraging it, you may want to keep that record because it may be helpful for you when you get misrepresentation or when you try to get deported from the airport. You may use that information. You can complain about the company and keep a record of that company though. If your lawyer has advised you that multiple filing is perfectly okay, you may want to keep that information too. It may be helpful too. I don't know if you can even complain against a lawyer too if the lawyer has advised. That's one thing that you can look into. Any other things, suggestions, what you would tell people that have already done the mistake? I'm not speaking of the people who are going to file next year, because I think so they learned the lesson. Even though we've been telling from past couple of years, everybody was thinking USCIS does not have the knowledge. They published it. They know that it's 95,000 people who colluded in filing 400,000 applications, and it's the employers who colluded. And these lawyers, some of these lawyers, I know one of the lawyer that filed 100 H-1Bs. With the same 100 H-1Bs, he filed for 7 different companies. So, of course, he is under, they are trying to prosecute him right now, and there are a couple of other lawyers that they are going after. Any other suggestions that you think that the people need to be aware of?
Yeah, I think if the petition has already been filed this year and it has not taken effect yet, if it's already approved or pending, the best thing you can do is get that withdrawn, because where the fraud comes in, that finding is that you obtained some sort of immigration benefit through fraud. The benefit is the approval of the H-1B petition. So if you get that withdrawn and you're not using that H-1B to work going forward in the United States, that is one argument that you can make is, hey, I realized my mistake. I chose not to benefit from that mistake, from that action, and therefore I can't be found inadmissible because I didn't benefit from it. I almost did, but I chose not to and had it withdrawn. So I think that's the number one thing. just don't rely on that. Don't file it would be the best thing you can do. But if you've already filed, don't rely on it. Have it withdrawn. Continue your F1 stay. Exit the U.S., change status to some other type of visa that you might qualify for, but don't rely on that H-1B that was obtained through these duplicate filings, through gaming the system.
One thing is that even if you are working for the employer and you got selected through the lottery, but if there is a collusion in the employer using other companies, don't file the H-1B with that company, even though you're working for the company. A lot of people have suggested that both companies should not be related. That's enough. That's not enough. Collusion is different. You scratch my back, I scratch your back. That is collusion too. Technically, in the language of the USCIS law, both companies cannot be related, but in this particular case, the collusion also will be illegal. Now, it's in legal language or a criminal language, we call that as conspiracy to commit a crime, especially filing an H-1B application fraudulently is a felony. If the employers have colluded together, it is conspiracy to commit the fraud. And if the employees have colluded with the company they wanted these people to file the multiple applications, they encourage these people, then it will be a conspiracy to commit the crime, though. Now, have we seen any time going against criminal actions against the employee in these kind of cases? No. Do we expect any criminal action against these employees? No. But what we are expecting is a lifetime ban on coming into the United States. That means that they can never come back, because if you have tried to do any fraudulent activity or misrepresentation in obtaining the immigration benefits, it is a lifetime ban. You cannot come back, not only just on H-1B, not on H-4, not on green card, not on H-4, not on F-1, not on any other visa. There is a waiver process. It's very stringent. We don't advise people to ever go there at all, though. So it's a lifetime ban. It's not like 3 years, 5 years, 10 years bar. It's a lifetime ban. You can never come back into the United States. And if you are in United States, they will deny your H-1B extension. They will deny your H-1B transfer. So it's very dangerous. You may want to contact your lawyer if you were involved in that. Anything else, Emily, before I go to the next topic?
Nope, we can go
on. The people who are getting laid off right now, of course, I see Ankit Gantara is asking a question: how do we survive in the recession of very similar to 2008? Of course, you have seen 2008. I have also seen 2000, 2001. Yes, it's going to be very hard. Now, suggest some of the options, Emily. If I'm getting laid off, of course, 60 days is, everybody knows that they have a 60-day grace period, and they can find a job and find an H-1B and start working for a new company. Everybody knows that. But what about any other options that are available, though, if I don't get a job in the 60 days?
Yeah, if you are married and your spouse is also on H-1B, that's probably going to be your next best option, is to file a change of status to H-4. Because in that way, that's a relatively straightforward application. Once it's approved, you can always file a change of status back to H-1B without having to go through the lottery in the future. As soon as you find a new job, that can be filed in premium processing, and you can start work as soon as that's approved. The next option, if you are nearing that 60-day grace period and still don't have the job offer and you don't have the H-4 as an option, would be a B-2 visitor visa. Again, that would be a change of status. It's on the same application form, the I-539. Why is the H-4 better than the B-2? Because the B-2, you can only request a 6-month stay, maximum of 180 days, versus the H-4, which you can request for the entire validity period of your spouse's H-1B. But if you have to do the B-2, make sure you file it before day 60. You can file it online. It's relatively straightforward, and you get an immediate receipt notice if you file online. If you want to work with an attorney to file it, you have to file it on paper. So you want to file it probably at least 2 weeks before the 60 days are up so that you can get that receipt notice back in case there's any delivery hiccups or delays there. But that would then allow you to stay for an additional 6 months. And during that 6 months time, if you do find the new job offer and your B-2 is still pending, you can actually have the new employer file a change of status back to H-1B. And if it's done in premium processing, USCIS has come out and said that they will, as a courtesy, adjudicate both the change of status to B-2 and the change of status back to H-1B together at the same time. So you can get back to H-1B without having to leave the United States, because in the past you would have to exit, you would get the approval for consular processing, and then you have to wait for the visa stamping and all of those sorts of things. So that would be the next best option. Beyond that, assuming that there's not another type of visa category that you qualify for, and maybe your I-94 is expiring soon, to where you maybe can't take advantage of the full 60-day grace period because it gets cut short if your I-94 doesn't last for at least 60 days. Maybe the I-140 compelling circumstances EAD. I put that on the bottom of the list because it's really important to know that it does not provide you status. It does allow you to lawfully stay in the country, but you're not in any status. So in order to get back into H-1B status later when you do find that job offer, the only way to do it is by exiting the US and getting the new visa stamp to come back in. But it does provide employment authorization, so you can at least, once you are approved, you can use that EAD to work to make ends meet while you continue to look for the next step in your career. So those would be kind of the most common things. Back in 2008, I would say it was very common for people to change status to F1. I would say that may be an option for some people if they are going to a legitimate school and want to actually, go back to school for their master's or something like that. But going back to school to get day one CPT at those so-called day one CPT schools, I do not recommend that because we're still getting RFEs. I just saw one today that came through by fax. We're still getting faxes these days on a premium processing cap subject H-1B petition, requested a change of status from F1 to H-1B, and they're on day one CPT with a school that starts with C. And asking for proof that that day one CPT was validly issued and that the person was actually attending classes and a full-time student and all sorts of things. So those issues are still there. So I don't recommend change of status to F1 for most people. If you are going to do it, it's got to be a real school, not one that's for the purpose of day one CPT.
Emily, I just want to reiterate people why we are a little bit different lawyers, a little bit more conservative and probably practical too. It's been proven with regards to the multiple filings, with regards to the day one CPT also, we have a different opinion as compared to the other lawyers' opinion though. It's up to you whom you want to take it. I know you are under desperate situation, okay? I know that's the reason why most of the people have filed a duplicate application. It's like this, my mother is serious, I have to take her to the hospital. Can I rob the bank? No, you can't. So we can't advise people to do the illegal activities though. Why do we consider the day one CPT universities as illegal is that, look, there is no admission policy for them. Even I am as a lawyer, if they apply in the master's in computer science, they're going to give it. I don't need to have a bachelor's in computer science. There is no 101 course required for most of these universities. Then you ask them, when does the university start? The answer is whenever you want it to start. Really? That's a university? And then they say you have to attend 6 days of classes in a year. That's what the days of I used to attend when I used to go to law school. Per week, I used to attend 6 days. So all these things should cite. And let me ask you this question though. What about the University of Texas? Why don't they give the day one CPT university? What about the Harvard University? What about the University of California? Berkeley doesn't give it. Why not all these universities are giving? Only these Harrisburg, Cumberland, and a couple of other universities that are giving. You need to get an idea of what kind of agencies, what kind of universities these are. Please don't get into the trap of day one CPT. You can go back to India and come back. You can go to a very proper school and come back. You can do a lot of different things, but don't get into the day one CPT trap. Coming to the third topic, a lot of people ask the question, my employer is not giving the I-140 approval, or I left the employer, or I'm with the employer. I don't know if my I-140 has been withdrawn within 180 days after it's been approved. Simple. You can file a Freedom of Information. It's called FOIA USCIS. It takes 10 minutes for you to do it. It costs less than 10 minutes for you to fill. It costs no money, and they will take 6 weeks for you to give the I-140 petition. On the I-140 petition, on the front page of the I-140, you can see when the petition has been approved, if it's been withdrawn, on what day it's been withdrawn. So especially, we all know that if the I-140 is approved for more than 180 days, not been withdrawn, you have a lot of benefits, including the H-4EAD, extending the H-1B. These are the benefits you have it. If they are withdrawn within 180 days, you don't have the benefits extending beyond the 6-year and the H-4EAD. Now, to actually look to file the Freedom of Information, I would recommend to file after I-140 is approved for more than 180 days. Because if you apply the Freedom of Information within 3 months after filing the 485, after approving the I-140, you may get an information saying that it's not been withdrawn, but it could be withdrawn later on. So I normally recommend you file it after 180 days. Now, once again, the information is that where you can go and search and find that Freedom of Information. It's called FOIA USCIS. You fill an online application, you get the thing within 6 weeks. Anything else, Emily?
Nope, I think we can move on there. Oh yeah, and with that, you will also get a copy of your labor certification approval that was submitted with that I-140 petition, and that's very helpful for future labor certification filing, so that you can ensure that all of your information is consistent from one filing to another. And it's also helpful if you are later using AC-21 and looking to change jobs, and you want to make sure your new job is in the same or similar occupation. That labor certification approval will provide you with the SOC code, the wage level, the job duties, job title, and all that information. So it's good to have that regardless of whether you're with the company or not.
Well, we always say buy one, get one free. Now here, get the first one free, and the second one also comes free for you. With regards to the 485 pending, guys, you can, if it's been more than 18 months, we strongly recommend you can contact the ombudsman. That's one thing that you can do. But the best thing that we advise people is that do not contact the USCIS to adjudicate your 485 application when your priority date is not current. They cannot legally do it. I do get some consultations. I do get a lot of people asking me, oh, my priority date is 2014. I have a lot of different hard circumstances. Can I request the USCIS to expedite the 485 application? No, they do not have that authority. The only thing that you can do is that go to the Congress. That means with the Parliament, what we call in other than United States, and get it approved. That is not practical for at least 99.999% of the people, though. So if your priority date is not current, don't waste your time requesting them to adjudicate your application. But if your priority date is current and it's been more than 18 months, you can try contacting the ombudsman, congressman, requesting the USCIS to expedite. If they don't, which most probably will not happen, you may want to consider suing the USCIS. That may be a very good option for you to do it. You can contact Stephen Brown in our office. He'll be the right person if you want to sue the USCIS. If it's been pending for more than 1.5 years and your priority date is current. Anything else, Emily?
Yeah, I think, the difficulty with USCIS is their service request system is somewhat okay in that you can do it online. The problem is you can only do a service request for cases that are outside the normal processing time. So they claim that normal processing time nowadays is what, I don't even know, 24 months. I stopped looking because it's just ridiculous.
No, it's a lot more than that.
Yeah, probably 48 months at this point. And so they use that as a way to say, you can't contact us yet because it's still within normal processing time. Well, I'm sorry, normal is completely unreasonable if you're telling me it's going to take that long to adjudicate a simple 485 application. So The next best thing, I've not had much luck recently with the ombudsman when you're still within normal processing time. They get contacted so much that they really focus only on the cases where they can actually get assistance, provide assistance, or there's someone who's about to go out of status, or clear government error, those sorts of things. So I have had some luck by reaching out to different congressmen's offices. It doesn't always happen immediately, but somehow once they start looking, we start to see some action happening. So you can do that. You go to Google, find my representative, and there'll be a website for the House of the Representatives where you can enter in your zip code, and it will then pull up who's your representative. Sometimes you have to put in your street address because there are multiple representatives that for one zip code. But once you get that, then you'll have your representative, and there'll be a little link where you can go to that representative's specific website. Once you're on their website, there's going to be a button for you to get help with a federal agency. Click on that. You'll be able to fill out your information, provide your address so they can confirm that you're one of their constituents, mention that the agency is USCIS, provide your 485 receipt number, filing date, and a basic overview of why you're contacting them. And then you can submit it online usually. The congressman's office will then reach out to you normally to have you sign a form confirming that you're giving consent for USCIS to release information to the congressman's office. Once you've signed that and submitted it back to the congressman, they will then reach out to USCIS and wait for a response. Many times USCIS comes back 5-6 weeks later and says, hey, it's within the normal processing time, there's nothing we can do. But sometimes after that, we all of a sudden see the case start moving. So that's probably going to be your next best bet. If the date is current and you're just not seeing action and it's not hit the 18-month mark yet.
A lot of people have asked the question with regards to why can't you take a class action suit with regards to those people who have genuinely filed the applications, they did not get selected in the lottery. Well, it was being tried before and it was failed. And we're going to have a video separately tomorrow. Me and Stephen are going to present that to you guys because that's a very lengthy discussion which we'll not cover today. One other thing is that if the H-1B gets revoked, though, those numbers will be added in the year for which the H-1B gets revoked. So, for example, they're revoking the cases that were filed in 2021. So they're going to add those numbers in 2024 because, so 2023 or 2024, depending on when it's been revoked, though. So that's something that I just want to inform you. And the other thing we want to inform you about this multiple filings is that we already filed a freedom of information somewhere in April of 2023, requesting the USCIS how many, before they release the information, how many people filed the duplicate applications, how many companies filed the duplicate application, what information they have. We requested that information, and we requested that information. And we are also intending to sue the USCIS we are intending to sue the USCIS with regards to the issue of not giving us the freedom of information. One second, we have some technical issues. I will go to the question and answers. The question came with regards to if I move to a different company and if the SOC code is changed from software developer to the medical scientist, can I retain the priority date? Because that is a very drastic change from software developer to the SOC code. This question comes from Naveen Reddy, and the answer is yes, you can. Yes, you can. Will there be a second round of lottery? Yes, we are expecting a second round of lottery. We're expecting a second round of lottery this year too. The reason is that a lot of the people have dropped down. They're not filing the H-1B applications because of the duplicate applications. According to us, 60% of them are duplicate applications. So we're expecting a lottery.
One of the questions was, what happens if, I'm assuming this is a company, drops all of the H-1Bs that they planned to file this year because of the duplicate filings and decides to try again next year? Is the applicant, the employee, still in trouble? In our experience, we have not seen that, at least in terms of, USCIS saying that the person is inadmissible for fraud or misrepresentation, because you have not actually sought an immigration benefit if your H-1B doesn't actually get filed. It doesn't mean that you're completely in the clear, because a lot of times what we see is USCIS and FDNS are conducting these fraud investigations, and that bleeds over to the consulate. So in the future, if you exit and have to go for a visa stamping, they might be questioning you at your interview about this company that filed all these duplicate H-1Bs a few years ago, even though you never filed the H-1B with that company. And when that happens, many times they issue a 221G, putting you in administrative processing before they'll issue the visa, and you could be stuck there for months waiting for that to be completed. So although you may avoid the fraud finding or misrepresentation finding, you still could face issues at the consulate, at a green card interview, or things like that because of these companies.
Can I do first-time stamping in Canada if I have a Canadian PR but living in USA? Yeah, absolutely, you can. You can do first-time stamping of H-1B in Canada. Even if you don't have a PR, you are still eligible to go to the first-time H-1B stamping in Canada. Ankit, with regards to how to survive in the recession while on H-1B, we will do a separate, probably 10-15 minute session separately though. That's going to be a major topic, so we'll do it separately. Probably we'll do it in the next 2 weeks.
Rajan says, what happens if I have an EB-1 485 filed but get laid off? What would the status be after the 60-day grace period ends? So I think it depends on what type of EB-1 this is. With the EB-1A, there is no job offer requirement, so it does not have any impact on you as long as you're still intending to work in your area of expertise. With the EB-1B or C, then we have to look at, has it been at least 180 days since your 485 was filed? And in that situation, you qualify for AC-21 and can take the green card process with you to a new employer once you land that new job. What a lot of people get confused on is they know there's an H-1B grace period, so they assume there's also a grace period for the EAD, or the adjustment of status, and there is not one. So when you file a 485, you have to have a valid offer of employment, unless it's one of the categories that qualify for self-petitioning. And so if you lose that job, you need to still have a valid offer of employment in order to actually receive the green card. And there's no grace period that gives you a 60-day window to find that. So you need to be working on that right away. Now, when does the valid job offer come up during the 485 process? After the time of filing. Typically, it's going to be if your 485 has been pending for some time and now the date's about to be current, you'll usually get an RFE asking for a new supplement J to be submitted. So you need to have the job offer by then. Or if you're called in for an interview, you have to bring the supplement J there. So you need to have the valid job offer by those 2 points. In between that time, that doesn't mean I'm saying that you can just hang out without having any job for a year or two. You should be trying to get that new job offer as quickly as possible. But where the biggest risk lies is at the time of an RFE or at the time of interview. And so if you're still at that point, not having a valid job offer, that's when you need to look into other options. Self-employment is even an option for the supplement J. So you could start your own business that's in the same field and still be able to receive the green card. It's not my first choice, but that is an option. So we would always recommend that you contact an immigration attorney if you are in that situation.
Emily, what are you expecting next year? Will there be any change in the H-1B processing? I know that they have issued some proposed regulations, which we are not happy. They were increasing the fees to $200, from $10 to $200, which I'm not happy with it. They should have collected the entire money. What are the proposals right now that could change all these things?
Yeah, I think as of right now, we don't, besides the fee increase, we don't have any proposed regulations where they've already issued the proposal and we've already commented on it and we're just waiting for them to respond. So I do think they plan on issuing new regulations to address some of these issues with the fraud. I think they're thinking that the increased fee will help with that. I highly disagree with that. But a lot of people have been talking about, well, why don't we make it one applicant, one registration? And I don't see that ever happening. And the reason for that is the statute guarantees that you can have multiple approvals. And that's what the court actually used as the reason why what USCIS did was proper, even though they failed to address the fraud, is because it was still having this registration process and allowing the multiple filings is in line with the statute. And the only way you can change a statute is Congress and the Senate have to agree and put forth something new, which that's very unlikely to happen. So if you're thinking that they're going to issue some regulation that says only one registration per employee, I would not expect that. And two, I mean, could you imagine if the employee has control of the registration? How many registrations do you think would be submitted then? Because they don't have to have a company. There are going to be a million registrations, people that don't have a job offer, people that don't even have a bachelor's degree. Who knows? And so I don't think that's the solution. I think increasing the fee beyond $200 or requiring the filing fees to be held in escrow or charging the fee the second that petition gets selected, go back to the old system. I hate to say that because it was a pain to get all of those filed, but maybe that was a better system. But there was still duplicate filings under that old system. But as of now, I've not seen any actual proposals from USCIS beyond the fee increase.
R.K. Reddy Panala is working in India for XYZ company, but he got selected with a different company. Should I go for the H-1B lottery? No. If you're working with XYZ company, the XYZ company filed an H-1B for you, that seems to be simple to me because you're already working for that company in India. Now, if some other company got selected, most probably either you collided or the company collided in applying the H-1B where there's no job offer for you. I do not recommend you to come into the United States. If you want, you can have a consultation with a lawyer. We can go through the entire scenario, how, if the job is still there for you, and if it's 100% certain, then we can actually let you apply for the H-1B and come here. But otherwise, don't do it. You may be permanently barred to come into the United States.
Jenna says, I filed a B2 extension for my mother online well before the I-94 expiration date, and the case is still pending. What do we have to do? So when you filed the I-539, you would have requested a specific end date that you want the B2 status to expire, which can be no more than 180 days from the time the current status expires. So it's very likely that the B2 application is still going to be pending once you get to that requested end date. At that point, she needs to exit the U.S. Because she cannot keep staying, even though the application remains pending, she cannot keep staying beyond the date that she initially requested. So let's say that you filed it in June, requesting a December end date. As long as it was timely filed before the current I-94 expires, she can stay in the U.S. up till December while that application is pending. If it's still pending by the time you get to that December end date that you requested, she should exit the U.S. by that point.
A4 Investment has this question that his wife got the H4 stamping, which expired in 2020. She moved to H-1B. They're going to India. Is she eligible for the drawback? The answer is yes. Until December of 2023, they have given exception for people to apply even if their visa is expired long time ago, even if they were never on the same kind of visa. For example, people moving from F1 to H1 or H4 to H1, they have given exception until December of 2023. Most probably they may extend it, but for now, it is until December of 2023. Question from, go ahead, then.
Wants to know, is a visa number allocated before the I-485 approval or after? And with the last quarter starting in July, how many visa numbers are pending for EB1 and EB2 India? So the visa number is allocated. It's the last thing they do before they can click the approve button. So it's not done after. It has to be done before they can approve the 485. If there's no visa number, they can't approve the 485. In terms of how many are pending, I haven't seen any of the statistics on what they've done in the first quarter and the second quarter. We may be getting those in the near future, but I don't think they've been published yet as far as I know. So we have no idea what is in the pipeline at this point. The last numbers we got were in, I think, September 2022 through litigation, when we found out that the visas were running out for EB2 worldwide. And then they let us know how many applications remain pending beyond that. But that was all done through litigation and discovery, not through those publicly available data.
Sai has this question. His wife's H-1B extension has already been filed or approved. And recently, she is getting her I-140 approval or is going to get an I-140 approval. Can she file an amendment saying that she's going to work remotely and file the H4 plus EAD because he doesn't want to get any interruption in the employment? Absolutely, yes, you can do so. There are very many creative ways of filing an H-1B amendment. I mean, very many creative ways. If the employer is cooperative, you can file a creative ways of filing an amendment. USCIS loves the money. There's nothing wrong with it because anyway, they'll get the premium processing too. You will get the H4 plus EAD. That's the reason why we're getting creative in filing an amendment of the H-1B. Remote work is one thing. Maybe your salary has increased by $1 or $2 per year. You can still file an amendment. Is it required to file an amendment when your salary has gone up just a little bit? Maybe not. But if you want to, if the company wants to, the USCIS will take the money.
Gummy Bear says the 485 EAD AP combo renewal is in progress. Got the receipt notices. Can I re-enter the U.S. with the AP renewal receipt notice if I travel out of the country while it is pending? No, do not do that. Absolutely not. If your previous AP has not yet expired, you can travel and come back before that AP expires without impacting the pending extension. But once the prior AP has expired, you cannot use a receipt notice to come back to the U.S. There is no auto extension of advanced parole like there is for the EAD.
AKC 5247 has this question. Can I file an EAD and AP renewal more than 200 days before? We tried it. It worked. So he's saying, do I need to go with the company lawyer because he's going to refuse to file? You don't have to go with the company lawyer. You can file by yourself too. It's not that hard of an application, but there is no obligation for you to go with the company lawyer. You can even go with a private lawyer too. You know, our office charges $150 if you file with our office for each application.
Gokul says, do we have to return the green card if the first and middle names are swapped, and will travel be an issue in this situation? So you should get it corrected at some point. I would say if you do have travel plans, I would wait until after you return to request the correction, because you have to give them the wrong card and wait for them to give you the correct card, and that can take weeks or months. And so if you initiate the correction and you send in the old card and you have no card and now you need to travel, that's where you're going to have difficulty. I've not had anyone have trouble traveling when the card has a typo like that and coming back. So go ahead and travel. And then once you're back, plan to get that corrected.
Question from Kumar from Facebook. what are the documents that are required when I'm traveling with advance parole? Typically, 485 receipt notice is good enough, but he has listed whether I should carry the pay stubs, employer letter, I-797, I-120s, educational documents. You may want to carry all those things, but don't show to the USCIS all those things. They'll get confused. What is this guy showing all these things to me? I only need an advance parole. Practically, advance parole in 485 is good enough, but the rest of the documents we recommend to carry, but don't show it to the CBP official. Only if they ask, if they request, then you show it to them.
Kenan says, when does the H-1B 60-day grace period start, specifically for states that have the WARN period, W-A-R-N? So there is no guidance on that specifically. The safest way to operate is based on your last actual date of employment. So if you have received advance notice of the layoff through the WARN Act and you're still working through that notice period, you're still considered to be in H-1B status. And then once you stop working, the 60 days begins from there. There was some discussion before about whether you can count severance pay. If you stopped working and then maybe you get 3 months of severance pay, does the 60 days start at the end of the 3 months? There's some wiggle room there where we've been able to make some arguments because we have those recent pay stubs. I think if the company has already withdrawn the approved H-1B, which they are required to do when they terminate employment, that wiggle room goes away. But sometimes it's possible to count severance time, but mostly it's safest to go based on the last day you've actually worked.
Anurag has this question. He went for H-1B stamping, got a 221G, got a notice of intent to revoke for the H-1B, and they already responded to notice of intent to revoke, and he wants to withdraw his application. He wants to apply for he wants to withdraw his application and file for H-4 stamping. And does he need to answer, has your visa ever been refused? Yes, the answer should be yes. And you should give them the 221G, what was been issued. You need to answer yes to that question. But I'm a bit concerned though for you. Two things though. When you're getting all these things, you should have gone back to H4 a long time ago instead of waiting for all these times. By the time USCIS is issued a notice of intent to revoke, you should have gone for H4. If you had that option before, you delayed a lot. The second thing is that I'm a bit concerned about this notice of intent to revoke, the reason for the notice of intent to revoke. If there is anything fraud allegations that have been made, if that is so, though, I may not want you to apply for the H4. Wait and analyze, or wait for some more time before you're going to apply for H4, or maybe probably move to a different country. Because if there is any fraud allegations, they may hit you with a permanent bar for you to come into the United States. And USA is now sharing the information with Canada, England, Australia, I think so, New Zealand, and a couple of other countries. So it may not be advisable to get a permanent bar from the United States. And Canada, I'm sorry, I forgot it. So it may be shared with the other companies. So you may want to be careful if the notice of intent to revoke has been issued.
I and my wife are on H1 and H4 and have GC, EAD, and AP. If I travel and come back on the AP while my wife stays in the U.S. in H4, what would be her status when I use the AP to re-enter? So as long as you are coming back to work for the same H-1B employer that you had when you left, and under the same terms and conditions, and that H-1B has not expired and has not been withdrawn, you can consider yourself to still be in H-1B status, even though you re-entered on AP, which means your wife can still be considered in H-4 status, even though you re-entered on AP. So as long as you're coming back to your H-1B employer and complying with the H-1B, it doesn't automatically make you use AP, and it doesn't make her automatically lose her H-4.
Chandra has this question. He has EAD and AP from EB2 and EB3 category. If he doesn't renew one of the EAD and APs, that either EB2 or EB3, is it going to deny the underlying 483 application? The answer is no, it does not. They will leave as it is, so they are not going to deny the underlying application. Question from Girish Aradhya. He is not on payroll. His H-1B is expiring on May 31st. Expired on May 31st. But he's not on the payroll. And he's on GCEAD. Girish, if you are the primary applicant, you need to contact a lawyer, though. The reason is that I don't want your 485 to be denied because you don't have a job offer either with your current company or for a different job. It's going to impact your green card application. But if you are the dependent 485 application, though, and you don't have a job and you don't have the H-1B, you're good. You don't have a problem. You have a GCEAD, you don't have to work if you're a dependent.
Akil says, I'm in the U.S. and lost my passport last year due to a burglary, and I have the police report. I have my I-797 valid. Am I eligible for Dropbox if I visit India? Possibly. So as you're going through the DS-160 visa application, it will ask you various questions, and it will then tell you that you are eligible for Dropbox or not. So even if you meet all of the requirements that are listed on the consulate's website for Dropbox, sometimes they still don't let you use Dropbox. So having the lost passport before, I don't think that automatically kicks you out of the Dropbox option, but you'll know as you're applying for that. You can be filling out the DS-160 now, and it will give you the option or tell you you don't have that option and you need to schedule an interview.
Nunal has this question. Multiple H-1B applications have already caused damage due to folks who agreed to collude in the first place. Have any employers been charged for colluding so far? What penalty are they looking at? Yes, there are a lot of companies that are under criminal investigation right now. We get a lot of contact from people who are getting criminally investigated, the employers getting criminally investigated. Some of the employers are running away to India. Some of the employers are just closing the entire business. Some of the employers are not filing the H-1Bs even though they got selected in the lottery. So all different things are going on, and it's spreading around a lot of prosecution of these employers. Were employers prosecuted for filing in 2021? Yes, they did. Now the question, Runal, these things don't come out is, remember previously 2 years ago, people, let's say for example, you're a very nice guy, you only applied for one lottery, and this other guy who applied for 10 lotteries, he got 5 or 4 selected. He was beating his chest and saying, I got my lottery. But now, when the prosecution happens, when the revocation happens, they don't announce that information though. But yes, we do get the consultations. We do get the information. Unfortunately, we can't put them on the video though. We can only put nice people on the video because the bad people, they don't want to come on the video, and we don't want them, I mean, as a client and lawyer privilege, we don't want them to come on the video and announce their name. If you did not get selected in the lottery, you're a single guy, yeah, you want to speak something, yeah, we would like to promote it. But if a client is consulting us saying that he filed for 17 H-1Bs and he got selected 4 or 5 times, we don't want to put that guy in there. If that guy, they don't speak though. So yes, they are getting prosecuted, they are getting investigated, and that's the reason why they're packing, some of them are packing their bags, closing the companies.
Charisma says, can I have both a valid H-1B and H-4 visas stamped on my passport, or will the H-4 be canceled if I go for H-1B stamping? And if I do have both visas, can I choose to enter on the H-4? So yeah, when you qualify for 2 categories at the same time, the Department of State and their Foreign Affairs Manual, there is a provision that allows you to keep both visas in your passport. So you, as long as your spouse is still maintaining H-1B status, you can have the H-4 visa stamp and also get the H-1B stamp. And then you can choose which one to use at the time you're entering. As long as your spouse is continuing in H-1B status, you can use the H-4, or as long as your H-1B job remains available, you can enter on the H-1B.
Viber was asking with regards to the GCEAD, can I start my own company? Can you do the video? Normally, we try to avoid videos when there is a lot of gray area, though. When there's a clear, crisp idea that this is wrong and this is right, we try to do the video, though. It would be better for you to consult a lawyer, though. Yes, can a GCEAD person do business on top of working for a company? The answer is yes. But what kind of business you want to do it, you may want to consult a lawyer. Especially when people are doing immigration, signing the H-1B petitions and all those things. I'm a bit worried about them, though. But generally, though, if you're just doing any business like a restaurant or something like that without involving in immigration, we don't have much problems on it. If your primary employment is still the IT field, and as a secondary employment, let's say, for example, you want to open a restaurant on a GCEAD, we don't have a problem.
Emmanuel has a great question. Why isn't USCIS updating these barred employers and listing them publicly? Why are they putting people at risk of getting employed by them? I think that there is a provision for barred employers when it comes to LCA violations. When it comes to these registrations, once the company gets caught, once they start getting these notice of intent to revoke, they disappear. The company shuts down, they leave the country, but that doesn't stop another one from popping up in its place. So yeah, they can list publicly that ABC Consulting Company filed all these duplicate registrations and they're a bad company, don't go to them. Well, ABC Company no longer exists, and that same person is going to start XYZ Consulting Company. And nobody has any history on that company because it's brand new. So it doesn't really do them any good, in my opinion, to do that. And even if you say, okay, well, publish the owners of those companies. Well, the owner's just going to say, hey, my friend over here is going to start XYZ company instead. So they can't cross-check and see that there's a relation there. So even doing that is just, you cut down one, the next one is just going to pop up 3 days later. It's like whack-a-mole.
Neha is asking a question. There are two answers to it. One is ethical answer, one is legal answer. I'm an H-1B and I got the GCEAD. If I want to work for a different company on an EAD, do I need to inform my employer about it? Legally, you may be fine. You're perfectly fine. Ethically, it's a different issue, whether you want to inform it or not. As far as the legality is concerned, you're under no obligation to inform the other employer that you're working with a second job in EAD. You don't have to inform, you can do 2 jobs. Filed 2 applications with 2 different employers. J2 interviews coming up, not picked up in the lottery. Mayur, as Emily has pointed out before, though, if the H-1B is not selected in the lottery, not picked up, and you didn't file the H-1B, we haven't seen any permanent bars yet for the people. Yet. The reason why we say yet is we see a lot of aggressive moves right now from the USCIS, from the CBP, from the consulate. So you will be our experiment. You go and you get the stamping and you tell us what happened, we will tell other people. Mr. Mayur has gone. Of course, we won't tell your name. Mr. X has gone for J2. He didn't have any trouble. So we need some more feedback because this is a recent trend that they're going very aggressive on the people who file the multiple applications. Even though they have been revoking the H-1B application that have been filed in 2021, especially hitting with a misrepresentation, a permanent bar, is a very recent thing. Mayur, I don't want you to be the scapegoat. If you can avoid it, I would like you. I don't want you to scapegoat. I would, if you possibly can avoid for the next 5-6 months, and then I get somebody else, not the persons who listen to our channel, that would be much better. But it's up to you. If you have forced to go for it, then, well, you don't have much option there.
Arnav says, we applied for our 485 last year in December. Until now, we've not received our EAD or AP cards. So litigation is a great option for that. We are routinely filing lawsuits in that situation for these delays in the interim benefits is what we call them. So you can reach out to Stephen Brown, Stephen@rnlawgroup.com to see if you might be a candidate for that and what all the requirements are. But that would be a good option.
Anything else, Emily?
Nope, I think we're out of time for today. Thanks so much for joining us. As always, you can see us on any of our upcoming conference calls that we have daily through Zoom. You can get the schedule for that by going to rnlawgroup.com. And you can always schedule consultations with any of our attorneys here at Reddy Neumann. We have our appointment system online, so it's super easy to book. You can select your attorney, select your own date and time, upload any documents that you want us to review, and we'll be prepared to discuss with you at the day and time and get all of your questions answered. So thanks for joining us, and we'll be back next week.